Good morning. Are you Micah Powell?
Yes, ma'am, I am. Good morning.
And this is cause number 25 DCCR 1522. Mr. Powell is charged with burglary of a habitation. Mr. Minaldi is here on behalf of Mr. Galmore, who filed an application for writ seeking reasonable bail. Looks like the bond is currently set at $50,000. Ms. Minaldi, you may proceed.
Judge, just based off of Mr. Galmore's request, it's clear that with his family having an interest in his case and supporting him in that case, he would be here for court settings if he were to be released on bond. He does have the proper means to get to his attorney's office. He does have the proper means to get to court. He has motivation to show up and handle these cases. He's not a flight risk. He's not at risk of not showing up in that capacity. We're just requesting that he have a bond set that he can afford. I believe Mr. Galmore has requested it be decreased to $5,000 so that he can afford it. It's clear that he cannot afford the current amount of $50,000.
Put some evidence on with regard to that. Raise your right hand, please, sir, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you. Go ahead.
Do you have access to any type of savings accounts in your name?
Yes, I have two different bank accounts.
Okay, where are those bank accounts?
Ready Financial and a credit union out of Galveston. Can't remember the exact name of it.
And about how much do you have in those accounts?
About maybe 901, and the other one was probably maybe I had one of them was for withdrawals.
estimation.
Probably about 1,400 total.
Okay, and are you employed currently?
Due to my incarceration, I am no longer employed, but I do have somebody willing to take a chance on me and give me a very good job opportunity for release.
Okay, and is that job located in Jefferson County?
It would be over in Pasadena.
But
But I drive. I can drive back.
you would be able to come into your court settings?
I'm looking to get this settled because I cannot go on my life with this over my head.
And then do you have any type of cash or any money outside of those savings accounts that you mentioned?
I do hand over fist fishing guide services for anybody who requested to give me supplemental income.
But do you have any actual physical cash that is supplement to those savings accounts that you mentioned?
No, I'm not currently.
Okay. Do you have any assets, stocks, bonds, or anything like that that you could access to help make the current bond? And then do you own any real property?
Any questions?
There's not argument.
All right, go ahead, Ms. Malfino.
Judge, I would respectfully object to the bond being reduced, especially to an amount of $5,000 for a habitual offender who has prior burglaries for which he has served pen time. This will be a pen time offer. In this case, I believe the offer extended by Mr. Smith actually went below the minimum 25 of his habitual status, but we don't think that any bond lower than 50,000 is justified, judge, based on his criminal history, and would ask the court to take all of that into consideration.
So I am going to take judicial note of the court's file. Need a drink? You good? Including obviously the indictment itself that alleges prior convictions, burglary of a habitation, second-degree felony from the year 2000, two different ones from that same year, an evading arrest or detention, third degree from 2007, another burglary of a habitation, a second degree from 2018. Looks like all of those, well, we've got Galveston County, Tyler County, and Harris County alleged, and Jefferson County. So I also have reviewed the probable cause affidavit in this case, and the allegations in this case looks like, at least according to this, that the allegations are that Mr. Powell was actually trespass warned from the owner of the house's job, that there was some type of harassment in the past or some relationship that caused some issues where he was actually trespass warned from a job location, and that there is apparently video footage of this offense as well. based on all of that and the fact that he would be considered a habitual offender, with this being his fourth allegation of burglary of a habitation, if anything, that bond, in my opinion, is low based on all of that. I'm going to deny the writ and find that, or the request of, based in that writ, and find that the current bond is sufficient, I guess. I don't really think it is, in fact, but I'm going to keep it at least the same for now. All right. And we'll reset it for an announcement. You can go back with the bailiff.
Thank you, Judge. May I be excused?
Yes, ma'am. Thank you. It was 50 or 20?
It was 50, Judge.
Okay. Ms. Benaldi, I'm also, just in case it wasn't already, I'm sure it's a condition of the bond, but I am, if you'll let him know, going to make sure, if it's not a condition of that bond, that he have obviously no contact or communication with the complaining witness, and also that he is not allowed to live with the friend that lives across the street from her.
Okay.
Okay,
And I'll make
can't be anywhere near the house or job.
Okay.
Okay,
Thank you,
thank
Judge.
you. And I'll make that notation on the order, and you guys, it'll be filed. You'll see
Okay,
it later.
thank you, Judge.
Mr. Kelly, are you ready on Dalton Batiste?
You approached it? Thank you.
Right, sir, are you Dalton Batiste? And this is cause number 25 DCCR 1436. Mr. Batiste is charged with manslaughter. 25 DCCR 1437 charged with manslaughter, and 24 DCCR 0407 charged with possession of marijuana. The cases are set for trial to begin with jury selection next Monday. And what is the announcement?
Couple issues, if I may, Judge. Mr. Coleman and I have talked extensively, not only this morning, but in the last lead up to today, and there has been a new proposal put in front of us that I think we'd like to ask for at least a little bit longer than today to consider. I know that also Mr. Coleman has responsibilities to folks on his side to discuss it. Or like this. Sorry.
Take a break. Why is this one? This one's not showing up on my. What is it? It's on my.
Actually, I was trying to see it for me. He was being very difficult. But now it says Tom Kelly, so that's why I believe,
Oh,
because I had changed their co-counsel and he was trying, I thought he was signing them out.
okay.
Couldn't walk the
Sorry.
tablet.
And then
You okay? You need some water?
I've got, you want cough drop?
Oh, I do have that.
I think the sinus is the best.
Yeah. Yeah.
No, it's fine. Well, okay, so here's the thing, there's only 2 defendants left on the trial docket for next week, so I need to know something today.
My other issue, Mr. Gertz asked me to say this. He is set in Judge Templeton's court
Oh,
on a case, Austin
Yes,
Jones.
especially if
Been
that,
tried previously too.
And that's next week.
That's next week.
Yeah, I'm not sure that I should have taken that into consideration. So obviously that is a specially set case for Mr. Gertz over there. And we've done a protection order for him to get that case taken care of since it's an injury to a
I
child.
understood, Judge. I think we're very close to resolving this case. Still notwithstanding the other case, I
Okay.
still would like to try to push this case to get resolved.
Sure. So here's what I'm
Like to
gonna
talk about
do.
victims.
So what I'm gonna do is, just for a short time, take it off the trial docket, place it on a review. In about 3 weeks. That gives you and Mr. Gertz time to visit with Mr. Batiste, Mr. Pullman time to visit with. Anybody he needs to visit with, and then if something gets worked out, we'll take care of it at that time in 3 weeks. If not, it'll go right back on the trial docket and we'll go from there.
Understood.
Sound good?
Yes, sir.
Okay, you can go back with the bailiff.
Thank you. Thank you.
Hey, Ms. Holmes, you've got Jacoby Frazier.
Yes, Your Honor.
I was in the midst of signing him up, however, out of an abundance of caution, I think he needs to be
Is that the
evaluated.
one that was out here?
Yes.
Yes. So we'll reset Mr. Frazier and you can just do our order. We'll get an evaluation order today. Darius Derry.
Deary.
Thank you, ma'am. Good morning. Are you Darius Derry? And will your client waive the formal reading of the indictment?
People, Your Honor.
Mr. Derry, in cause number 26 DCCR 0234, you're charged with the state jail felony offense of burglary of a building from December 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Berry is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 100 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff. Kevin Thomas.
We did a rejection.
Yeah, got it. Thank you.
Bring that video back from.
I put it in the file. I put it in there. Yeah.
Good morning. Are you Kevin Thomas?
Yes.
And Mr. Thomas, in cause number 26 DCCR 0798, you're charged with a third-degree felony offense and assault on a security officer from March 17th of 2026. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, August 28th of 2000. And then after that was final, you were convicted of burglary of a habitation, second degree, September 29th of 2008. And then after that was final, you were convicted of possession of a controlled substance, a third degree felony, March 30th of 2021. 2 cases of possession of a controlled substance on that day. And what that means, sir, is that if you go to trial in this case and you're found guilty, the range of punishment would be that of a habitual offender, which means it would be a minimum 25 years in prison up to 99 years of life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Ms. Holmes that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on, it looks like maybe count 1 and count 2 to make this a second degree for a 15-year term in prison. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Mr. Coleman, is there any reason to believe that offer would change?
Not at all, Judge. And in full disclosure, while the 15 years is a formal offer, I did make a today only offer for less than the 15 if the defendant was amenable to that, and he's rejected that as well.
And what was that for?
I believe 10.
Yeah.
10.
So you understand if you wanted to enter a plea of guilty today, there's an offer that was extended today for 10 years. Obviously that's going to be off the table, as will be the 15 after today. Do you understand?
Yes, ma'am.
All right, so we'll get your case set on the trial docket. Mr. Thomas, Ms. Holmes has been appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and we can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Ms. Holmes, you'll be released. Mr. Thomas, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.
Thank you.